compared to Boston. Second Amendment to me is very dear. I am no one on the House floor to fight. As once I get on the House floor, I'll grab the leg of anybody that's fighting against the Second Amendment. And I'll explain more about that as we go along. And I do want to just real briefly, if you don't mind, as former Representative Don Gorman is up back. He came down as a friend of mine, and also the current Representative Sheriff Burke is up back.
I'm Rob Luther. I'm Clerk Judge Maine on the 7th Circuit, and these views are mine, not the views of the court or him. Before I clerked, I was in practice for 5 years in Virginia, working with a fellow HLS alum, also Clerk Justice Blackman. And we had a private practice that also had a large public issues component. So we did a lot of first, second, and 14th Amendment litigation. Also taught at William and Mary for a year, and I've been working on public issues, fellow issues for about 8 years now. So when I was in practice in 2010, a guy walked into our office and said, "I'm a felon, and I was convicted of marijuana possession in the 80s, and I'd like to get my firearm rights back." I'd only been in practice for a few years at that point, but I thought, well, I don't think you can get them back. Your felon said, "Oh no, I can, and my friend has already got them back." So I looked into it, and it turned out he was right, and that experience sort of started my interest in this area of felon and mental health restoration for disabilities that federal and state law impose after conviction or involuntary commitment. So that's really the more narrow area of interest that involves my interest in this area. What I'm prepared to speak about. If you have any questions on that.
Great. I'll try to get back with the Brady Center, but for now, if you all could share your perspectives on the current gun legal and policy landscape as it sits today.
John, do you want me to go? Yeah, sure. So I'm just going to talk about some of the cases that have happened since Heller and McDonald. I mean, I'm not sure how familiar you are with them, but in 2008, the Supreme Court decided Heller. In 2010, the Supreme Court decided McDonald. I don't know if you've read them. They're a few hundred pages long, so I'll just hit the highlights. Basically, the court said that the Second Amendment is an individual right subject to reasonable regulation. And so naturally, the follow-up question now is, what sort of regulations are reasonable? Should handguns be treated differently than assault rifles, treated differently from hunting rifles? Should regulations permitting only the purchase of one gun per month be upheld? Should you have to register your guns with local police? Should felons or people with history of mental illness be barred from possessing guns forever? What should the standard for receiving a conceal and carry license be if you've been a law-abiding citizen your whole life? So I mean, those are some of the more recurring issues that we're seeing in the district and circuit courts in the aftermath of Heller and McDonald. So I think the circuits have been cautious in their application of these cases. Laws that have regulated rather than restrict have tended to be upheld. Of course, we've looked at the burden with proximity of the encumbrance on the right. I think that this regulate versus restrict distinction has been followed fairly consistently amongst the circuits, maybe with the exception of the Second and Fourth Circuits that have allowed regulations not authorizing conceal and carry to be upheld even for law-abiding people. When it comes to specific cases, I think we see some wins for gun advocates, some losses, and some ties amongst the circuits. Pretty much the first big circuit case after McDonald was Ezel, which came out in the 7th Circuit in 2011. In that case, the city of Chicago, not to be deterred by the Supreme Court's decision in McDonald, said, all right, well, if we have to issue license, if we have to allow people to have handguns, we're going to require a 8-hour training course, and then we're going to bar training courses from the city. So that really happened. So that was challenged, and our court struck that down as a violation of the Second Amendment. Another case, a newer case that hasn't gotten as much attention, but I think is very important, is the Sixth Circuit case that came out in December, Tyler versus Sheriff's Department of Hillsdale. In that case, Mr. Tyler had been involuntarily committed to a mental health facility 28 years ago. He had no issues since, but because he had been committed, he was subject to federal 18 U.S.C. 922 G4 prohibition against possessing a firearm. Now, some states since 2007 have enacted state restoration proceedings to have your mental health burden on firearms be eliminated, but Michigan is not one of the states that has allowed this. So basically, Tyler was locked out, frozen out from any sort of remedy to have a hearing on whether he could possess a firearm. So he brought an as-applied challenge to 922 G4, and the Sixth Circuit agreed and said that under Heller and McDonald, you have a Second Amendment right to at least go to court to try to explain your case for why this prohibition shouldn't apply against you. So the court didn't issue didn't restore the right, so to speak, but it allowed him an opportunity to make his case then to the lower court to basically get an exemption from that statute. So I think that's really one of the only wins I've ever seen for mental health folks and guns. We want to speak about regulations that have been upheld since McDonald and Heller. The DC Circuit, the 2-1 case of Heller 2, they upheld an AR ban. They upheld a requirement that you register your guns in DC with the police, over at the Senate. Since those cases, people with the domestic violence misdemeanor conviction have failed every time in their attempt to get that statute overturned. It's 922 G9. There is really no restoration process for those folks because they're not felons, so they are frozen out from any sort of relief. And again, back to the mental health folks, the 4th, 9th, and 11th circuits have all rejected facial challenges basically to the mental health prohibition. So arguably there could be a circuit split there, but I think it's a little more nuanced because Tyler's challenge was an as-applied challenge. He had brought a declaratory action versus those 3 circuits where people were raising Second Amendment defenses to criminal prosecutions. I think that matters. I think the procedural postures of these cases matter. If you really are trying to change the law, you probably don't want to be raising it after you've already violated the law. So, and then I guess the last thing I would say is there are some ties. Whether the Second Amendment applies outside the home. The 7th Circuit, Judge Poser's opinion, and the 9th Circuit opinion say yes. The 2nd and 4th Circuit say no. Those cases dealt with concealed and carry permits, which is a very hot topic in all the states. I think John's mentioned there's some legislation concerning that right now in the state, and this would be a good time to transition over to him.
Yeah,
so,
thank you. Sure. Is it Luther? Luther, I'm sorry. Mr. Luther said at the beginning, what gun laws are reasonable? I'll tell you right now, not one is. 0. And everyone in this room should understand that. 0 gun laws is what we need in this country. Other than for the bad guy. And he also said about the DC upholding, those few rulings. Again, they shouldn't be doing that. And let me explain why. Because the only people this is hurting is probably your parents. Law-abiding citizens. Because guess what? The bad guy is still going to get his gun. The bad guy is still going to do crime. And the bad guy is still going to shoot us. And if we don't have the right to carry and bear arms, we're not going to have the right to defend ourselves. Because bottom line, when seconds count, and in that situation, seconds do count, the police are minutes away. So you think about that while you're waiting for the police saying, damn, I wish we didn't have that gun law. Because that affected me. Now, what I want to talk about is constitutional carry, also known as Vermont carry. That is spread in the country. There are many, many states that are looking at it right now. And what constitutional carry does is it allows me, because I grew up in Vermont, I didn't realize when I moved to New Hampshire that I had to have a license. I was in New Hampshire for 9 months, and all of a sudden somebody said, "Oh, you carry a gun?" And I said, "I wouldn't leave the house without it." What, are you crazy? It's a scary world out there. And so they all looked, they said, "Well, you must have a license." And I said, "What's a license?" So he explained it to me. And I said, "No way." So I called my friend at the police station. I said, "Hey, Cecil, what's the deal on this license in New Hampshire?" I said, "The guy's pulling my leg, right?" And he says, "Oh, no, you've got to have a license." "Why?" "Oh, nothing." That was the end of that conversation. So I had to go and beg the government to have my right. We don't have to go to the government and say, "I want to go protest, and can I have the right to speak against the government or speak against Harvard or against Massachusetts or anybody? Can I have that right to, please?" No, we don't have to do that. But we have to when it comes to the gun, the Second Amendment. So what constitutional carry is doing, Maine is going to pass it. So there's going to be Vermont, Maine, New Hampshire's passed it out of the Senate.
You're probably going to want to hold that thought.
Start up again as everyone's going to go on lunch. That was probably the most efficient 80 people getting box lunch in their seats. Good job, everyone. That was great.
And hopefully everybody all speak up a little bit. If you can hear me. If somebody can't, just holler. I've never been accused of not speaking loud enough. I am saddened to hear that Elizabeth Burke cannot join us. Now, I'm just guessing. I'm guessing that she probably Googled my name and said maybe this is the time to turn the Skype off. But I do, thank her for trying to join in. And where I was talking about constitutional carry, also known as Vermont carry. What constitutional carry does is it allows you, the law-abiding citizen, because I'm assuming every one of you are law-abiding or you wouldn't be sitting in here. It allows you to carry a gun without begging the government, without asking permission, without anything. Just putting it in your pocket and walking down the street, going to the store, doing whatever you want. It allows you that right. And that is what our founding fathers wanted. Now, what happened is early in the 1900s, Vermont forefather saw the gun control, and I understood it started coming out of New York City first. So they hurried up and changed the Constitution. And that's why Vermont now, the most liberal state in the nation, still has 0 gun laws because it's in the Constitution. Now, they did try to pass a background check for everybody. About 1,200 people showed up on the front steps of the State House and said, "I don't think we want that," and they defeated it. But I'll get back to the constitutional carry, why I think this is so important for you all to hear it and to make sure that this is your goal in your life, is to make sure that your state passes this. It has passed out of the New Hampshire Senate. It has passed out of the Criminal Justice Committee, which I sit on in the House. And now it's going to the House floor for a full debate, and I'll be speaking on it. I have done the numbers, we have the votes, and we'll pass. Now it will go to the Democrat governor, where she doesn't know what she's going to do with it yet. The anti-gun people on the one side say she needs to veto it, but she wants to run for higher office. And next year, we have a House bill that is identical to the Senate bill. And if she vetoes this one, next year during election time, we're going to have another constitutional carry bill sitting in front of her with all of the news media looking at her saying, "What are you going to do with this one?" So she has to determine, does she want it now and just let it pass 5 days without signature? It becomes law. She can just walk away from it. Or does she veto it and then have to deal with that law or the bill next year when the news media is looking at her because she's running for higher office? The state of Maine is going to pass it. I've talked to the representatives up there. There's 124 reps. 77 of them signed on, so the governor's already said, get it to my desk, I'll sign on to it. Kentucky just passed it. Alaska passed it several years ago. And again, it is crucial that we keep this momentum going. I understand that it's being looked at in about 10 to 12 other states this year, and hopefully we can pass it in more states. And again, I just cannot come back to why we have to have it, because it is your right. Because those darn criminals, they just will not follow the rules or follow the Constitution or anything else. And I don't know how to make them. That's the problem. You know, we can pass all the laws, like down here in Massachusetts or DC. And look how Chicago, the most restrictive gun laws in the country. And it's worked out really well for their crime rate, hasn't it? Now, Vermont, I like going back to that, has 0 gun laws, and Vermont is the second safest place in the world, next to Switzerland. You know, how can you beat that? New Hampshire, we do have to have a license, sadly. I didn't like getting it, but I did get it. And we're the 3rd safest state. I understand Massachusetts, I believe, is around 23, 24th safest state. And then you got DC and the other states, they're in the toilet. A lot of crime, but they have the most restrictions. So that's it on that topic right now that I can think of.
Okay, let me expand on that by talking about the mechanics of the conceal and carry applications that John is referencing or alluding to. You know, as I said, the 7th and 9th Circuit, they said you have a right outside your home, and the 2nd and 4th Circuit said you do not. So what are we really talking about? What are these applications? What do they look like? What do they contain? The issue is whether the state law says if you're a law-abiding citizen and you apply and pay the fee and have the minimal training, you shall be issued a conceal and carry license, or you may be issued a conceal and carry license. And as you all know, there's a big difference in law between the word shall and may. Shall means if you don't have a felony conviction, there's no discretion, and the local sheriff or local clerk or whoever does it in your jurisdiction or state is different needs to issue this permit, and you're good to go. However, if you're in a may state like Maryland or New York, it means that the local person has the ultimate say, the sheriff or whoever the person in your jurisdiction has the ultimate say on whether you get your gun or not. So a person with the exact background in northern New York may get it. A person with the same background in New York City may not. And this is, there's obviously a circuit split on this issue now, on each side, and this is a very contentious issue, of course, because a lot of people really feel like they're law-abiding, if they don't have the right to carry a gun with them to defend themselves in public, their Second Amendment rights are being, they're liable, they have the perspective they're liable are at stake. So that's how that issue has broken down. But it's really just about what state you're in and who your local issuing authority is. People that have been denied in the Second and Fourth Circuits brought these suits saying that may is a violation of the Second Amendment, and the courts have said no, local government has the discretion to issue these interpretations according to their own will, and if you don't like it, vote them out, basically. So, in this whole process, it's a moving target between legislation and courts and case law, because the doctrine is still developing, because the main basis just came out a couple of years ago. Is there anyone want to add on that?
No.
Okay. Someone had asked about, again, disabilities and restoration relief. How does someone who was a felon or who had been committed to a mental health facility, how do they get their gun rights back? Again, it differs by state. In 1986, when Congress passed the Gun Control Act, they passed statute 18 U.S.C. 921-820, which basically says if states give you your gun rights back, you won't suffer a federal disability anymore. So that basically redirected all this stuff to the states. And most of the states for felons have adopted processes that allow a relief proceeding. About 40 of the 50 states, all the states in Fourth Circuit, California even. The big difference is what the state's proceedings require. That's just completely different all across the board. In Virginia, if you got a nonviolent conviction years ago, it's $80 to file a petition. Your proceeding in front of the judge might be 15 minutes or less, and you're out of there. North Carolina, it's $2,500. Your conviction had to have been 20 years ago, and you can only apply once every 5 years. In California, your crime has to have been at least 5 years, and you have to pay the fee, but the burden is on you to prove by a preponderance of the evidence that the burden is on the state to prove that you shouldn't have the gun. So every state is just very, very different in this capacity. On the mental health front, in 2007, Congress passed a big mental health piece of legislation after Virginia Tech, which coincidentally was 8 years ago today. As part of Congress's efforts to get states to get on the same page with their mental health histories, they issued the money to do that, but as a condition of accepting that payment to consolidate these records, they also required them to enact these state mental health restoration procedures for guns. So at this point, about 24 states have accepted this money, consolidated mental health databases, and then they have enacted state proceedings to allow people to get their records clean, so to speak, so that they're not subject to the same state and federal disabilities that felons or anybody else would be subject to. Now, very few people that I know have ever done a mental health restoration disability proceeding, because I think a lot of people don't want to get involved in that. But what's happening now is, now that it's becoming a little more prominent, now there have been some cases, the mental health profession is getting into this big time because they're really uncomfortable with these things happening. And the article that I'm looking forward to publishing in this journal is a response to a 50-page study of mental health professionals proposing additional encumbrances on these state restoration proceedings. And a couple of them that come to mind that I discussed in my paper are, first, they want temporary detention to impose federal disability on you, even without a hearing and even without due process. So if someone calls the police and says you're unstable and they show up at your house, they want that to eliminate your firearm rights even before you've ever had an adjudication by the court. Right now, the rule is you don't lose your rights until a court has said so. And the First Circuit, in the opinion by Judge Goodine from this school, said that's due process, plain and simple. And I think that is the right decision on that. Another thing they want to do is make testimony of a mental health professional a prerequisite for jurisdiction at a mental health restoration proceeding. So unless you have found one of them who's willing to testify for you and you're willing to pay them their expert fee, you can't even go to court to make your case. I think that is a conflict of interest, and I think it's bad policy, because I think that they're perfectly capable of assessing people's employment history and family background and life in the past 10 or 20 years, just as well as any mental health professional. And third, they want to allow temporary taking of firearms at the issuance of a phone call saying that you're at risk. So again, the problem I see with that is There's really no check on whether the call is in good faith or anything. Basically, someone can come in and say that someone called and said you're unstable, and they can just take your guns, and after 10 days, you can petition the trial court to have them returned to you. You know, again, regulations versus restrictions. I think these are some very serious measures that have a lot of potentially negative consequences, and not necessarily for society, but for the people whose possessions are being taken away from them without due process. I mean, really, you know, my perspective in some of these cases, they really focus on due process, and that is really the key here. It's not, you know, whether any particular person should have a firearm or should not be capable of having a firearm. It's whether there are enough procedural safeguards in place to allow someone to at least attempt to make their case to the state to have their firearm rights returned to them. Someone asked specifically about a felon restoration proceeding. Basically, in Virginia, if you have your voting rights restored from the governor, you can then go to court to have your gun rights restored. The Supreme Court of Virginia has said only courts can restore gun rights, at least in Virginia. So what do those proceedings entail? You basically file a complaint, just like you would in any civil case. You attach the document saying the person's got his voting rights back from the governor. If you're smart, you attach a couple letters of recommendation from people that the court might know, or at least will credit. And then you have a hearing with the prosecutor who actually represents the state in these proceedings, even though they're civil in nature. You know, you would want to have some witnesses for your client, you know, as an employer or a friend or a well-respected member of the community, in case the judge decides to take any testimony. And you know, then you have your little mini trial, put your client on the stand, have him say how he's got his life in order, not violent, you know, how he just wants to go hunting with his friends, that sort of thing. And, you know, usually the state won't try too hard to oppose this unless you're in a really bad jurisdiction. You know, I mean, again, if someone did something wrong long ago that's nonviolent, I think there's really a good case to be made that should impose disability forever. Although, you know, I've had cases where that has been the prosecutor's perspective. Fortunately, I've won every time, but that's only the take on the cases that I think we're likely to see. I mean, I wouldn't take a client who had a violent past, and certainly would take a case of a client who had a violent past with a firearm. You know, you have to use your professional judgment when you're meeting with people who decide if you think they're a threat to the community or not, or you put your name on the paper in court on their behalf. So that's pretty much it.
Well, on these, the other section that we're supposed to talk on is what should we make of our recent shift from federal to state legislative initiatives. And what I say to that is that it should come back to the states. You know, the federal government was not put there to run the states. The states run the federal government. Sadly, over many years, it's turning around the other way. I don't know if any of you are from New Jersey. Wow, no, just one. I will never live in New Jersey. And the reason is, if you have a .22 shell, a long rifle shell, which is about this big, very tiny, smaller than a pencil, and if it's a hollow point, all you need is one in your pocket. You don't even need the gun with you. And you have an automatic 1 year in jail, just for having the bullet. Now, does the state have the right to do that? You know, I think it's going against the Second Amendment, but that's where the laws should be made in the state. It's like here in Massachusetts. This is another state I wouldn't move to, and it's because of the gun laws they have down here. In Massachusetts, that's locked off. I like coming down here. I just feel naked when I'm down here. And what it is I had a good dear friend of mine who's passed away a couple years ago, Hal Miller. He was the CEO of Houghton Mifflin Publishing Company right here in Boston. He was the CEO for 18 years. First day on Iwo Jima Island. I'm sure you all know where that is. He was the first day. And when I was sitting in his house over in Lincoln, I said, Hal, what did you do? He says, well, you learn how to keep your head down. And I mean, he said it was bad, real bad. But this was probably 10, maybe 11 years ago. He was mad. Boy, was he mad. Because he had to go to Concord, or is it Lincoln? I think he had to go to the Lincoln Police Station and be fingerprinted, photoed, and pay a huge fee to carry his gun. And he told this, the police chief there, he says, I fought on Iwo Jima Island. That was the first day there. This is not what I fought for. Because as he said, the criminals are not going to go to the police station, be fingerprinted and pictured, and so that's why we have to stay away from this. So as you go out into your law practices and everything else, and you start seeing laws being made, if you're sitting on a bench somewhere, you guys got to remember, the criminals will always have them. You know, it's sad. I mean, for example, you know, I guarantee you, could you do me a favor?
Sure, maybe.
This Saturday night, I'll give you my email address and my cell phone so you can text me. I know how to text. I want you to go to Lowell at midnight. Lowell, Massachusetts.
Maybe.
And I want you to respond back, you know, walk around for a couple hours and then report back how that went. Because I heard there's a ton of criminals over there and every one of them carry. And they're not supposed to. So that's why I just keep coming back to why we have to get away from these laws. These bills that are for law-abiding citizens. That's all they are, is it's to restrict you and your parents, me, and everybody else, because it will not affect the bad guy.
Speaking of legislation, I've mentioned there are state and federal restoration proceedings for state mental health commitments and state felony convictions. If you have a federal felony, you're barred from guns for life, period, unless you get a presidential pardon. And if you get one, congratulations, because I think there were 17 people that got one in the administration, and there were 34 before that, so they're highly sought after. So if you're a federal felon, you're done. If you're a state felon, you might be able to succeed if you're in a pro-gun state. But there are a group of people that are completely barred everywhere, and that's the people with these domestic violence misdemeanor convictions. Well, obviously not in favor of domestic violence, but there are a lot of crimes that qualify as domestic violence that are not your typical domestic violence crime. And so I think this is an interesting academic point, because you could assault someone and be charged with, depending on what state you're in and what statute they charge you under, it could end up being a domestic violence charge, whereas if a misdemeanor is that. You could be charged as a felon for assaulting someone, and you might actually be able to get your gun rights back. Whereas if you have a misdemeanor conviction, you have no method of getting your gun rights back, because you can only get a restoration if you have a felony. So I don't think that makes any sense. And I've seen a number of cases that are actually pretty bad, where some guys, you know, in a local court saying, is this going to affect my gun rights? The attorney said no, and then 5 years later he gets a felon in possession, and you know, he still has a copy of the transcript, doesn't matter. I saw one last year where the judge told the guy it wasn't going to affect his gun rights, and he ended up getting a felon in possession. No, sorry, you're out of luck. The state law is not an excuse, even if the state trial judge tells you. So what are the remedies? Where can this be changed if anyone wants to change it? Certainly legislatively, but more practically, I think it's an issue of prosecutorial discretion. It needs to start being exercised with a little more thought in mind. People that justifiably rely on lawyers or judges to discuss their rights should at least be able to raise that as a defense, I think. So that's sort of my go out and do good if you want to fix a little nuance in the law that I think could use a little correction. I guess, since we're probably running out of time here, I want to make a couple comments about where we're going from here. First, on that standards of review. We can talk about standards of review in gun cases all day because Heller McDonald didn't articulate a standard of review. And, federal courts and court of appeals, what we do is we apply standards of review to facts. So we really need to know what the standard of review is when gun regulations come up. Practically, most of the circuits adopt some form of intermediate scrutiny when gun cases come along. It sort of depends on so many different regulations what standard is more appropriate. Certain people think that strict scrutiny is more appropriate because the Supreme Court said it's an individual right, and other individual rights, like the First Amendment, get strict scrutiny to regulations. So which of those standards will prevail? I'm not sure, but the court didn't answer the question, and I guess they just decided to let lower courts figure it out. I mentioned a little earlier about the one guy who prevailed in the mental health challenge in the Sixth Circuit, and his colleagues in the 4th, 11th, and 9th all failed. The procedural postures matter in gun cases because if you don't violate the law and bring a declaratory action, seeking relief before you've done anything, chances are you're negotiating with the court from a higher position of strength than someone who broke the law, has been indicted, and is raising McDonald and Heller defenses in defense. You're just, credibility in argument, credibility on facts, I think matters, particularly in gun context. So if you're trying to break ground in this area of law, don't be doing it as a defendant. And third, empirical data. Like I mentioned, mental health people are getting more involved in guns, both for people with a history of mental illness and not. And their perspectives, I think, are valuable. However, they have uniformly been on the pro-regulation side. It would be more balanced and more helpful, I think, to have some folks on the other side. But regardless, empirical data is going to continue to play a big role in future gun regulation litigation. So keep an eye out on that.
Thank you. The last question is, where are we today? And what is my thoughts on what the future action should be? Where we are today is, I ask every one of you in here to get training to shoot a firearm. You've never touched one before. Get your concealed license. Buy a nice gun. There's a bunch of them out there. 38 Special is a nice, sweet little gun. Get more training and protect yourselves and your loved ones and your families. Because I can't stress to you how quick it can change. And then you'll wonder, well, it took 23 minutes for that cop to get here. What could I have done in that 23 minutes? A lot. Now, where I am today is I think of our history. Japan attacked us in Pearl Harbor. The emperor said, attack the manling. And the general defied his wishes. He said, we can't do it. And he says, what are you talking? I'm telling you, go do it. We can beat the U.S. military. We don't have an issue with that. We could take them out in a heartbeat. There's a gun behind every blade of grass on the soil of the mainland, which is true at that time. I think it's even truer now. And that is why we have to protect the Second Amendment. We cannot have regulations to law-abiding citizens. We have to protect it at all costs, because once we give it up, like they have down in England and Australia, they're begging for it back. Because now crime rates are, burglars, rapes, everything else is skyrocketed in their countries because they can't protect themselves. And lastly, is I just keep going back to why it is so important is because if we don't protect it, our great-grandchildren is not going to have it. Because some states in our government wants to take it from us. The UN wants to take it from us. They would love to disarm America. And we can't let that happen. Because there's a lot of people that depend on us carrying a gun to protect our country and ourselves in our states. Because there's a lot of bad people, sadly, out in this world that want to hurt us. But by us all protecting ourselves, and for every one of us in here, could you imagine what we could do if somebody came on our soil and tried to hurt us? It was just like 200 years ago, 250 years ago, 25 years ago. It all started right here in Boston. I could imagine the forefathers of Boston, what they think with the gun control that's down here today. They got to be rolling in their graves. So I just say, as you guys go through your life, try to protect and exercise the Second Amendment as much as you can. Thank you.
We have time for maybe a couple of questions.
So I have just two quick questions. So one, as far as the logic of, the criminals won't adhere to the laws, don't you think that would just basically argue that no law should be passed because if you pass a law against murder, murder is still murder. If you pass a law against rape, rape is still rape. The second question is, you kind of touched on the Second Amendment a lot, and there's obviously a valid argument that if you look at the rights as it came from England and as it was originally practiced in the colonies, and if you look at how the original proposals and the revisions that happened in the Second Amendment, they generally refer to this provision on religious exemption. So if you had a religious exemption to being in the militia, then it would exempt you from having to be compelled to carry an arm. And so, given all of that, don't you think that, or at least there's a valid argument that the Second Amendment is actually in context with preventing the federal government from disarming the states? And given that the Bill of Rights was a response to the concern that the Constitution as written was going to create an overpowered federal government, how do you respond to that kind of argument? So both the logic of criminals won't follow the law versus and the constitutional argument.
Well, I'm glad you brought that up because right here is the Constitution. I carry it with me at all times. Matter of fact, here is the New Hampshire Constitution. I also carry that. Article 9 and 10 is extremely important to us because it keeps the federal government at bay if we decide to exercise it, which we should. And when it comes to laws that we were talking about, like murder, I agree, we have laws and we need laws against murder. Now, if you, or not you per se, if somebody kills somebody, and if they did it with a gun, if they got life in prison, I don't care, or the electric chair, the way it is. But to have gun laws against the average citizen of America is where it's wrong. Because again, the criminal that wants to kill somebody is not gonna, he's gonna walk up, I don't know if you have those stickers on your buildings here, that with the little circle with the line through it says no guns and knives. Well, the criminal's gonna go up and go, oh, darn, I can't go in here. And he's just gonna open that door and walk right through, just like right here, right now, he could do that.
Right, so if I was in the airport, and the airport said no guns, bombs, knives, box cutters, is the terrorist gonna go, oh, no.
He's not.
Right.
Now, my friend Hal Miller used to hunt out west all the time. And he used to bring his guns on the airplane. Could you imagine that today? Matter of fact, 2 years ago, the Democrats were in control, and nothing saying if there's any Democrats out there, nothing saying against them. I know I'm in Massachusetts. But the Democrats passed a rule, only a rule, because they can't pass a law because it won't pass. Even the Democrats will vote against it. They passed a rule that there was no more guns on the House floor. So at the State House. Our state house is one of 12 states that allow guns in their state houses. There's 7 other states that don't have any medical towers. I put an amendment the first day we had Oak Hill House, January 3rd. I put in 2 amendments. One amendment was constitutional carry, to say, look, I'm gonna carry any way I want in here to do away with the rule, basically. The second one was, okay, we'll keep it concealed, and nobody will know, it'll be all a secret. But we can carry. The second one passed, so now we can carry guns back on the House floor. Because we have to protect ourselves. And like I said on the House floor when I argued it, I said, look, we pass a lot of laws that people don't like. Some nut comes in the gallery, I want to be able to protect myself. And the other representatives saw it, so we passed it. But no, thank you.
Unfortunately, we got in trouble last time for going over on our timing, so they're going to be class here at 1. I made everyone to come back up with us to the JOL office on the 2nd floor. We have cookies for dessert and coffee to continue the conversation with our panelists.
I'm not going anywhere.
Thank you all very much for coming.